All right. So we are back with the Business of Medicine podcast. We have Scott Radigan, who is self-identified as the functional lawyer. And we're really excited today about the episode because he highlights some key components from looking at a concierge Medicare opted out practice to when you should consent patients, to whether you can practice outside your state through telemedicine, and what you should be concerned about from a consenting standpoint in malpractice. So I'm really excited for you guys to learn from Scott today. And Davin, what are you excited about this podcast about?
I think the aha moment for me today was that we can still do the right thing, but if you have the right paperwork, if you have the right documentation, including consents and other things, it's just adding to your communication, right? The caliber of communication that you're providing people. You're allowing people to see in writing what it is that you're going to offer for them. And then there's no misunderstanding. There's clear expectations about what you're offering and what they're going to get. And so rather than looking at it from like a fear perspective, like, oh my gosh, I need to be afraid of being sued. It's more about, hey, how do I provide clear communication that, is on paper that we can all agree to, so that moving forward, it's from a place of understanding. And I think that's for me, a shift in maybe the way that I look at the legal aspect of practicing medicine.
Yeah, I think it really helps in establishing that partner relationship with your patient, right? And instead of it being, okay, yeah, I'm coming here and I'm going to help you. But as part of that, understanding the legal ramifications of how I'm going to help you, I think is really, really valuable. So we look forward to having you join us on today's podcast, and let's get started. Welcome to the Root Cause Business of Medicine podcast, where we explore what's broken in healthcare and what we can do about it. I'm Dr. Eric Lundquist, and I've been practicing functional medicine for the past 15 to 20 years. I'm excited to co-host this podcast with my brother, Dr. Davin Lundquist,
who's just beginning his journey into functional medicine. We come from different points on the path, but we do share a common goal. We want to rethink how medicine is practiced and help others do the same.
The U.S. healthcare system is in crisis, rising costs, declining outcomes, and physician burnout at an all-time high. But we found a different way, another way, a better way.
On this podcast, we dive into real stories from medical professionals who've stepped away from the traditional model, kind of like me, and have found a new purpose in integrative, functional, and alternative approaches to care.
These are authentic conversations with practitioners and friends who've redefined success, not just for themselves, but for their patients and communities.
Whether you're a clinician feeling stuck, a student seeking direction, or just curious about what is possible,
you're in the right place. This is the Root Cause Business of Medicine podcast. Welcome back to the Root Cause Business of Medicine podcast, where today we have a special guest, Scott Radigan, who is the founder of The Functional Lawyer. And if you're wondering, well, what is a functional lawyer? Well, you're about to find out, and we're super excited to have him on today as he has experienced all things functional medicine and business from a legal standpoint. So I think you're in for a treat today as we talk about some of the legal issues surrounding integrative and functional medicine. And I'm sure all of you who have opted out of Medicare or have tried to do membership programs or are doing concierge and insurance, like all of these issues come up. What legally can I do? In fact, just this morning, I was having a conversation with one of my partners in Texas, where we actually have to do a consent form for our patients, and it has to be very specific. We have to have the diagnosis and the alternative care that we're going to offer them, and the risks and benefits associated with that care. And then we have to actually have the patient sign that they understand this is alternative to the standard of care, and that they understand the risks and hopefully the benefits associated with the kind of care. So all of this kind of stuff comes up when it comes to legal and functional medicine aspects. So we're excited to have Scott today. Welcome.
I'm happy to be here. I don't know that I need to be here. You just nailed all of that. So good job. Episode over. Have a great week, everybody. But that was spot on what you said.
Well, we have plenty of questions for you today, but before we get started on some of the nuts and bolts, I'm sure everybody would be really interested to know kind of how you got into this. You know, what prompted you to really kind of tackle and become an expert in this specific area, this niche of legal medicine aspects?
Yeah, not unlike a lot of providers, although I'm not one. So my wife went through the journey. My wife's a physician. She's a DO.
Who we had on the podcast. So if you haven't listened to that podcast, please do.
Yeah, Linda Mattioli, DO, founder of Origins Incubator, and prior to that, Origins Functional Medicine, which is where my story starts. I had just gotten out of law school and passed the bar, as we were chatting before we started recording. And she started her functional medicine practice like 6 months later. We had a 2-year-old and a 6-month-old at home. But once the toothpaste was out of the tube, and when I say that, she learned about, alternative functional medicine. She just couldn't go back into conventional care after maternity leave. So started her own practice. And at the time I was working in litigation for, commercial clients, all the big banks, all the big mortgage lenders. At the time, a lot of mortgage, and this was in 2015 and 2016. So a lot of stuff was kind of coming with construction defect litigation out of the early 2000s housing boom. So I say all that to say was not a healthcare attorney. So what we did when she started her practice was went to the healthcare partner at my firm, 2 floors up, and paid him $3,000 for him to just say, I don't really know how to help you. And then didn't get the $3,000 back. Great attorney, not his fault, but his clients were more, it was a big firm. So insurance companies, hospital systems, that kind of client. Ended up going to, so $3,000 out the door. Then we found a healthcare firm that didn't know what was going on with alternative medicine. And that's what attorneys call it, integrated and functional medicine. And so we ended up paying them about $25,000. And this is 10 years ago, just really for the setup of all the good documents, some initial guidance early on. But then every time we got a question, it would just be, $600 an hour or $60 every 6 minutes, as attorneys like to bill. So, after that, because we wanted to do it the right way, after doing that and talking to some of Linda's colleagues, I learned that these were both very common occurrences. People would either do the second one, pay the $25,000, not knowing, because here's the, you don't sign on the dotted line like, yep, I want to pay 25. They go, here's a retainer, it's 5. And then a couple of weeks later, they'd run out and they're like, we need 5 more. And then we need 5 more. And you're sunk at that point, is how it typically goes. Or somebody pays an attorney that is healthcare, but doesn't really know this style of medicine. So either way, they lose. So at the time, what people were doing was going on Facebook and asking colleagues, or Googling it and then finding some random PDF online and then using that. And so, I left my firm and took actually a sales job selling a functional medicine marketing course. So I got to talk to big left turn, but I did not fit well with big law firm, culture, at least at this firm. So I was like, I can always go back, right? Very not too dissimilar from some of the functional medicine doctors we have here. Mm-hmm. And so, but doing so, I didn't make a ton of money. I wasn't that good at sales. Some might say I was poor at sales. Is that I got to talk to physicians over and over all day, which was great. Because then they would learn I was an attorney and they said, can you help? And at first I was like, no, I don't know anything about it. But they say, can you look at my documents? I'm like, all right, I'll take a look. Trying to sell them a marketing course, right? And so I would get their documents and they would be Frankenstein's of a thing, where it would be like Arial font at the top and then Times New Roman and paragraph 2 and then sometimes Comic Sans in there. I'm not making that part up. And so that was terrible. And not being a provider, I couldn't actually do the medicine, but I could support those that were doing this style of medicine, which I came to believe in with the stories that my wife was bringing home and incorporating, healthier, cleaner eating with our children as well. So long story long, started to decide that people at least need good quality documents. And that's where functional lawyers started to take shape I worked with a healthcare firm, paid them a lot of money, the same one. So they got a lot of our money to help me make sure these documents were good. And then did a lot of self-study in the interim, paid them to kind of pick their brain a little bit. And then launched really just a document purchasing site called Functional Aware. But then over time, people decided or were telling me over and over again that they wanted to ask me questions. They needed to learn more, that documents are just tools. Like, what happens about Medicare? What do I do with, as you were saying at the top, all of those questions. So Functional Aware now, as it stands, has all the documents plus guidance from me that's live support and a digital curriculum of all the questions I never want to answer again, that I've answered thousands of times, that you could get the answer to in 3 minutes without having to pay me by the hour to answer it one-on-one. So that's a funny way of saying there's a digital course curriculum plus live support every week with me, and then all of our documents as we add to it as well.
That's awesome. I mean, each of us has had our own journey and experience with trying to get legal advice in this area, which is still, I think, when you've been in it for 20 years, like I have, I like it. For me, it seems like, well, isn't everybody doing this? But then I realize it's still such a small percentage of practitioners that are actually doing it. And so it becomes a little bit of a challenge to know what you don't know in terms of, okay, well, what can I do to find out where my boundaries are from a legal medical standpoint, right? Am I getting myself into trouble, or am I doing okay? What do I need to inform my patients about, and what is, just considered standard of care that I'm just naturally doing as part of my agreement? So I think it'd be interesting. I have some other questions for you. Some of it's come based upon my own personal experience, but I would be curious, just, I'm sure in talking to all of these practitioners along, now that you've probably talked to probably hundreds, what are some of the pitfalls that you've seen where they, as you kind of got involved, you realize, oh, wow, they were really kind of setting themselves up for being at risk or heading down a course where that really was going to bite them in the butt if they didn't do something to shore themselves up from a medical legal standpoint?
Yeah, well, thankfully, knock on wood, we haven't had any issues with people that are working with me. But I have to battle every single day, and it feels like I've shouted this from the rooftops for 5 years now since COVID started. And I'll probably have to shout it for the next 5 or 10 years. But I think one of the biggest ones that people don't even realize is a huge risk, because there's either misinformation, well-intentioned or not, out there, is you can just call it coaching or call it consulting, and then I can practice anywhere. And then do ordering of labs and giving individualized clinical recommendations. Oh, but I'm not prescribing anything, so it's not medicine. Or I'm not taking insurance, so it's not medicine. And these are common myths that are actually at the front of my telemedicine book. I'm not trying to shamelessly plug it, but I've read a book on telemedicine law. It's trying to combat these myths, and it came out 2.5 years ago. So I still have to combat that every week when I get a new person telling me they just want to be a coach. And I'm like, well, what makes you think you can do that? And they're like, oh, well, my business, I'm in this business group, and they said, just give up my license and then I wouldn't have to worry about it at all. And I'm like, that's even worse. Don't do that. So,
man,
I don't know if some of these business groups are, well-intentioned, or they're just like, just go make a bunch of money and then don't worry about it, because enforcement is kind of lax, which isn't my approach.
Right.
And it's not the approach of people that end up coming to talk to me. I'm sure and I always talk about this, there's a risk spectrum. Some people would prefer not to know, and they would just want to go help people, and like, government regulation is just a bunch of bananas anyways, like, who cares? However, and one of the big arguments for some of these gurus is like, well, you create a big rapport with your patients, they're seeking you out, so they like you very much, and they're not going to sue you. Well, they only like you until they don't like you, number one. And then anybody that's been in practice for a long time knows you can't ever, go
please everyone.
bat 1,000 for your career.
Yep.
And the other thing is, it's not always the patient. It could be, another provider who doesn't like what you're doing. Either you're encroaching on their territory. Maybe it's their spouse at home who doesn't believe in this kind of medicine, thinks they're wasting a bunch of money. As soon as something goes wrong, they're like, I told you so. Or maybe it's their grown children if you have an elderly patient. Or maybe it's their estate if somebody dies. And so It's not always that patient who knows, likes, and trusts you until they don't. That's not how I would approach, like, just make them happy and then hope for a good result as my legal strategy. But on top of that, practicing without a license and going telemedicine to other states in particular, or calling it coaching, and that's how they would say telemedicine in other states. There's two main big risks on it. Number one is it's against the law. So you can't practice medicine without a license in a state where you're not licensed to do so. So it's not just criminal, which is jail time plus fines, also civil, which is fines and possible disciplinary action in your state of licensure. But also, your malpractice probably won't cover you in that state, particularly if you're not licensed there, and particularly if you're calling it coaching for some reason. So not only is it a crime, usually a felony, but also if something were to go wrong and your patient fell out of love with you, then malpractice doesn't help. So now it's out of your own pocket. So I would say that's consistently the biggest risk that I see. Some of the other stuff, the consents, as long as you're trying and showing your work a little bit, then there's some leeway there. But day to day, day in and day out, that's the biggest risk that I've seen, to answer your question.
No, I think that's great. So I heard you say, a few things about that in terms of some pitfalls. And this is particularly kind of, going towards telemedicine in general. We can talk about some other aspects of alternative medicine and integrated medicine, but it sounds like one is you're recommending, don't misrepresent yourself. You're a physician, you're practicing medicine. Don't call yourself a coach or a consultant and think that it's going to be okay if you're dealing with patients and you're making medical recommendations. Like you can't really get around that, right? You're really misrepresenting yourself from that standpoint. If you're consulting with a business about a medical business, not necessarily patients in what they should be doing from a diet and lifestyle. And just sticking to diet and lifestyle, it's still medical recommendation, right? They're not going to avoid saying, well, but I'm not prescribing anything, so therefore I'm not practicing medicine. Last I checked, if you're a doctor and you're giving any kind of medical advice from a lifestyle standpoint to a medication pharmaceutical standpoint to a supplement standpoint, you're still practicing medicine. Did I understand that correctly?
Yeah, absolutely. And I always cite to a case out of Florida where I happen to be licensed, but it's one of the best examples of this. It's from 1973. It's Supreme Court of Florida called Reams v. State. And it's exactly that. It's way back then, probably the late 60s, by the time this got to the 1973 Supreme Court of Florida. A gentleman was diagnosing people with nutritional tests, recommending lifestyle, food, and supplement interventions. And the Supreme Court of Florida said, this is medicine under the definition of what is practicing medicine in Florida. And that's still good case law. 50 years seems like a lot for us who are alive, but in the law, it's not very long at all. It's still very, very much good case law. It's what the other courts have to agree to until the Supreme Court changes its mind. But yeah, I mean, every state has slightly different definitions. But yes, how I draw the line, a lot of times in the definition of practicing medicine, and then telemedicine is just practicing medicine with electronics. The shortest way I could say it is practicing medicine is diagnose, treat, cure, prevent illness, ailment, symptom, or condition, real or imagined, by any means at all, basically. And that some of the state definitions actually use those by any means at all in this language. So for those at home keeping track and keeping score, if you're giving individualized recommendations, specifically or particularly if there's a test involved, then just assume that's medicine. Or at the very worst, that's dietetics, which is also a licensed profession in most states. But if you are saying, hi, I'm Dr. Jones, I'm a health coach, but you can, I'll order a test for you, and then I'll read the test, and then I'll make lifestyle recommendations. You're medicine, right? That's medicine.
That's great. And then the other thing that I saw, or that you mentioned that I wanted to just highlight again, and that is malpractice is state and region specific. Like it doesn't typically cover you unless you having an agreement with the malpractice insurance that you're practicing across state lines because you have a medical license to do so. So if I'm licensed in California and I'm practicing medicine in California, but then I start doing telemedicine for people in Missouri and Massachusetts and Idaho, and if I don't have a malpractice in that region or area, and somebody from that state sues me, first of all, if I'm not licensed in those states, I'm already in trouble. Two is if I don't have malpractice coverage for me being in those states, then I could be kind of left out to dry. Is that right?
Yeah, I mean, it all comes down to your policy. So they will usually, if you call your malpractice policy, they'll probably say, they're not going to answer a lot of specific questions. So they're like, does this cover me for doing chelation or something like that? The person on the other end of the phone is going to say, I can't give legal advice, but we cover you up to the scope of your license. What the heck does that mean, right? So we'll get into that in a second, standard of care versus scope of practice. But to answer your question, yes, there's some limited exceptions, right? So if your California patient is on a business trip to St. Louis, certainly they call you for a Z-Pack. Like you're not going to go to jail for that. Right. But if you are advertising and drawing patients from all over the country, and a lot of them are all over the country, probably wouldn't build my business model on that unless I was licensed in those, a lot of states. There's cheap and fast ways to get them. But at the end of the day, it's a couple $100 and some paperwork. And then you don't have to worry about felonies for yourself or paying out of pocket for lawsuits to your point. Now, how often does it happen? Not that often. If we're being honest, but you don't want to be the one that I'm writing a blog about in 6 months, right? Telling your story. And so we want about 1,000 for not getting sued, both for you in particular as an individual and also anybody in the functional medicine, integrative medicine. Now we're kind of seeing precision and lifestyle, longevity medicine kind of all going this way. Any of those people get sued, it's going to be in the headlines across, mainstream media doesn't love even integrative or, more widely accepted versions of this branch of medicine.
Yeah, that's a really good point. Another follow-up question to that is, because I've heard different opinions about this, but I haven't actually been able to see anything. It's been in writing is what I mean. It seems like there's kind of this generalized rule that if a patient is you're their primary care provider and they move out of state, that there is some kind of window of coverage where you can still kind of help them while they're trying to find a new primary care practitioner, so their medications don't expire. So if something comes up, that you need to help them with, isn't like necessarily an urgent care kind of a situation. Is there a specific time frame that has been identified in any states so far? Is it still just kind of perceived as you have kind of like up to a year, and then after that, that's kind of seems like that's a little too long to carry on that relationship? The patient should have been able to find a new primary care doctor. What are you seeing from that standpoint?
Yeah, as far as I know off the top of my head, I know Utah has specific language around this. So if somebody moves to Utah, then they're like in their written code that said you don't need to be licensed in Utah. If somebody has moved to Utah and you're kind of just handing them off care, because it's also a balancing act between abandoning a patient, right? Maybe they can't get in for a bit. They do have a time frame. I want to say it's 90 days. It could be up to 6 months. I don't know. Let's go look that up. Utah is really the only one that I know that has specific language around it. The rest of them will recognize it. Maybe it's not written in the code, either the regulations or the statutes. But some will recognize that. But I would say I wouldn't rely on up to a year. I wouldn't rely on 6 months. I know everybody here thinks they are the only doctor that can help their patients, but trust me, there are good doctors in every state that you can hand them off to. I'm not trying to be funny, but this is very common where people talk to me. They're like, but they moved out and I'm helping them. I'm like, awesome. There's probably a bunch of other doctors in that state as well. So I would say encourage them to find somebody locally, try to hand them off. Utah's the only one that does put a time limit on it. The rest of the states have either written or just kind of commonly accepted exceptions for infrequent or episodic care is the name of it. More and more states are also writing this in as well. Arizona, Alabama, and I believe Minnesota, I think just added it too. but they're now saying up to 10 visits in that state without a license. And this is 10 visits over the course of the year over all of your patients. So aggregate 10 patients, 10 visits in a state is infrequent enough where they're not going to like come after you for that. So whether somebody's traveling or whether somebody moves and seeing them 10 times in 12 months, that might be okay in Minnesota, but definitely not Utah. So you do want to check. And I would say as soon as they tell you they're moving permanently, just let them know, encourage them gently. They'll have to find a new provider when they get to their new state. And then I would say 90 days to 6 months probably be where I would advise my clients to start handing them off.
So a related topic would be someone who travels to see a provider who may have some expertise, whatever you want to call that expertise. It could just be expertise in, helping people get their life in order, their lifestyle in order. So if someone travels to someone's office, sees them, and they come up with a plan and get them started or pointed in a direction or even prescribe a therapy while they're there in front of them, how does that fall under all these different laws and licensing?
Yeah. And I hear this one a lot, and I think less and less these days, but people will say, oh, as long as they come to see me once a year, it's fine. Not true. There's actually a couple of, given what I said earlier, the infrequent episodic exceptions are still in effect. So if it's really one person and that's the only person you have from New Jersey or wherever, maybe it's okay. But I know of, and I'm tracking a couple lawsuits, one in California, one in New Jersey, where national specialists are suing the state for their requiring of these national specialists to be licensed in California and New Jersey, respectively. They're saying it's unconstitutional. Now they're not going to win. It's just, I won't get into the lawyer details, but they won't win, because if that were the case, if they do win, then all licensing professions would just be invalid. The basic slippery slope argument. But they are acknowledging in their lawsuit complaint that these are the rules, and we are forced to either have the patient come back and see us in Massachusetts and Pennsylvania in the one case. So forcing the patients to travel to us, or forcing us to have onerous fees to get licensed in their state, which is, $500 a year to do. So they're acknowledging, though, that they are national specialists, their patients come from all over, and that they need to be licensed where the patient's located at the time of the visit. So I wouldn't give a blanket statement that if they come see you in person once, it's fine, which is what I hear a lot. And most of the time in law, and I presume in medicine, it can't always be boiled down to if X, then Y, full stop, right? There's a lot more nuance to it than just, if they have diabetes, then we put them on insulin, right? There's got to be a lot more nuance to it than that.
Yeah, and I'm sure a lot of it is the intent, right? What's the intent behind? Am I taking care of the patient at the visit, or am I intending to take on a new patient who doesn't live in my state, and now I'm going to assume their care, right? And so I think that's always critical in legal aspects, right? What's the intent behind it? And you can kind of say what you want, but if it looks like your intent is that you're taking on a patient from another state that you're not licensed in, well, it's going to be a challenge. I don't think that'll stand up in court. Let's shift gears a little bit and talk a little bit about scope of practice, in terms, because I think this comes up particularly with medical boards a lot, and practitioners, and what's within their scope, what's not in their scope, what is actually associated with their, what's the standard of care for integrative and functional medicine, and how are you matched to that? Every state's a little different. I know they have different laws in each state. But it comes to mind. I was an expert witness on a case in Texas not too long ago where a provider was ordering, this battery of labs, which we now see with Function Health is basically standard with Function Health labs. But they were ordering these extra labs. They were doing some extra testing in their office, which was ultrasound. Nothing was really woo-woo. There was anybody who was looking at this could see, but it was the medical board or the physician who kind of was overseeing this felt like it was excessive, right? This is excessive testing. You're putting a financial burden on the insurance company and the patient by ordering this excessive testing. So I think that's one aspect we can look at. I think nutritional supplements and that aspect, I think, and then even some alternative therapies, IV nutritional therapy. I mean, I think we could probably go on for days just talking about this, but I'm throwing a few softballs out there for you to kind of knock out of the park for us. But what are your thoughts on that?
Yeah, I'm glad you brought up, comparing it to other providers. So before I launch into my long answer, let's set the stage of what is standard of care and versus what is scope of practice. Kind of hinted at it earlier, but a lot of providers who are integrated functional will get really spooked when they send their patient back to the PCP and the PCP tells the patient that's not standard of care. And the patient comes back to the integrated functional provider and says, why did you order this test? My PCP says it's not standard of care. And of course they would freak out, right? But it's not wrong. Neither of them are wrong. It's not standard of care for the primary care provider who has not been exposed to what the integrated provider is doing. So I'll give you an example. Scope of practice is at the licensed level. An MD is an MD. They have the same scope of practice in a particular state. There's some slight variations between the states, more so for other license types. But for now, MD, everybody seems to understand that one. So let's say 2 MDs have the same scope of practice. But depending on what they did after they graduated from med school, they will have wildly different standards of care. One illustration I'd like to give is somebody that goes to 3 years of residency, goes into outpatient clinic, family medicine, starts seeing patients. Great. Maybe they've done it for 10 years. Great. They have a wildly different education, training, and experience than somebody who came out of med school, went to a surgical residency, did another 3 years fellowship, did another 2 years after that at the world's greatest surgery, shadowing place. I don't know. Put the words in my mouth here for me. You guys can fill in the blanks. But spent like 10 more years before they were ever allowed to touch a scalpel without somebody that kind of overseeing them, right? Which one of them should be doing open heart surgery on your mom? Right? The surgeon. And it would be wildly outside of the PCP's standard of care to be doing open heart surgery unless they were the last 2 people on earth, right? And then there'd be nobody to sue her or him at that point. So I illustrate that to say, same license, 2 different standards of care, just based on their education, training, and experience. So people that have gone to allopathic med school, done the allopathic residency, just done the family medicine or ER medicine or internal, whatever it is, if they then choose to go and get additional education, training, and experience in integrative medicine, maybe it's in Arizona or at Irvine or wherever they go, even if it's not an institution like that, if it's at IFM or A4M or through a mentorship with a bunch of people that are out there doing mentorships, they have additional education, training, and experience. And so if they have the certification from a place like IFM, where Mark Hyman comes from, or from A4M, or a few of the others, that helps, validate what they're doing. And that's what lawyers, certification isn't really necessary. It's really the education, training, and experience is what I'm trying to say. So the certification is nice to say, yes, I have this education, training, and experience, but you can demonstrate it other ways. And I say all that to say what lawyers call that is a substantial minority defense. So it's called a prima facie defense to malpractice, which is a Latin way of saying it puts the burden back on the patient or the plaintiff, let's say, in order to prove that what they did was actually acceptable in medical circles. At least a small subset of the medical circles are doing it this way and doing it safely and have been for a while. So now the burden is back on the plaintiff to say, you did that negligently. And so medical board cases are slightly different than lawsuit cases, of course, because then it's like, well, did you perform the surgery? Yes, that was within your standard of care. But did you do it negligently? Did you leave a rag in or tape in, something like that? Or did you cut off the wrong knee or cut off the wrong leg, which happens, right? They would lose that lawsuit. So, but if you're doing things, to your words, not that woo-woo, accepted by your colleagues, your peers, you're within that substantial minority of providers, of medical practitioners. And I would say that's a substantial defense or prima facie defense to most malpractice claims right there. Especially if, to your point, you're giving informed consent that this is different than conventional medicine. And in my informed consent, I tell people there is debate in the medical community. Some people believe this is not evidence-based care. Some people believe it isn't real medicine. And if you go on Wikipedia and type in integrative medicine or functional medicine, you'll be shocked at the results still to this day. And so we just kind of lay all that out there for the patient. To your point, risks, benefits, alternatives to care. And one alternative is always to do nothing or go back to conventional care, because you don't want to look like you're coercing them into seeing you as integrative or functional. And now I just kind of lost my train of thought. But yeah, that's the guy in Texas who is ordering what you consider well within the realm of the substantial minority. Tell me the results if you know him already, but he should have been well protected based on your testimony, at least. And then demonstrating that this isn't crazy. It's actually accepted and actually good medicine for a big chunk of the medical field.
Yeah, and so in terms of that, let's talk about the consent a little bit more too, because do you feel like it's necessary that patients be consented at every new diagnosis, new practice, management, or treatment intervention, or can you have kind of a blanket consent, like, okay, you're coming in, this is an integrative medical center, so we have our list of kind of primary diagnoses that we treat, the primary kind of alternative and complementary treatments that we typically do, and you've now consented that you're willing to participate. If there's any, you've now opted out that you don't want to participate in those particular treatments. Do you feel like there needs to be, like, okay, so now they have a new diagnosis of diabetes, and we're going to approach that, but we didn't consent them for treatment of diabetes when they first came in. Do I need to now consent that patient again? Or every time they get an IV therapy, do I need to consent them again? Or if I'm doing regenerative therapy, do I need to consent them for every new treatment? Or, to what extent do we need to consent? I mean, I know that, and there's probably still some debate and there's a lot of gray area, but I would love to get your take on that.
Yeah, great question. I've never heard it phrased exactly like that. Some people are like, do they need to consent at any time they come in? And that's certainly a no. What I usually recommend is one for what you described as like just general integrative alternative medicine in general. And then, remind them of that orally, maybe once a year. You don't have to have them sign it every time they come in or every 6 months or even every year, but just it's good practice to, remind them of it. And then use common sense with the rest of it. So not for every new diagnosis do you need to have them sign that same consent form. But when you're doing something that's a little bit riskier, so you mentioned IV therapy, I would just have an addendum. So I have kind of shorter versions for IV therapy or peptides or GLP-1s or ozone or chelation or whatever that, would make somebody pause. That, okay, what is this? Even like red light therapy, which is relatively safe from what I understand. Some of that stuff is like, all right, what is this? What am I putting in my body? What's going on in my body? That kind of stuff. And so lawyers will talk about material risk. And those are the types of risks you put in these consents. But it's like, what would cause somebody to pause and maybe consider not doing this treatment? And then you should probably have a consent for that.
Great. And any specific like key verbiage points, right? I mean, is it beneficial to say this is experimental? You want to inform them FDA has not approved this yet. This is still experimental. There are some risks associated with it. Here are some of the risks we've seen in our clinic. Here are the benefits that we've seen by providing this. And here's some alternatives, right? I mean, that's kind of like the basic formula, right?
Yeah, it is. I don't think that you need to say it's experimental unless it is, right?
Okay.
There's some language in there about off-label use in mine. So off-label use of particular drugs. And so we kind of let the patients know about that. Because some people might go to their PCP and they're like, yeah, I'm on, prenatals. And they're like, why? Just make my nails look better or make my hair grow faster or whatever. That is obviously off label for that. And you guys might have picked up by now, I'm not really the most keen on all the medical terms out there. So these are my examples. Got to live with it, guys. But yeah, we do talk about that. And unless it is experimental, I wouldn't say that just because you don't want to. I mean, most people are fine. We go to the trampoline park and I sign my kid's life away if they die at the trampoline park. I don't even read it. I just sign the waiver. But most people are going to pause when they say this is experimental or it's not for human consumption. Unless that's actually true, I would slide that in there. Because you're going to get a lot more questions than are necessary.
I think when we had a conversation with your wife, she had some great insight into the difference between, sort of treating somebody in like an area of specialty, like you're helping them solve a particular problem, they're a challenging patient or whatnot. You're not necessarily becoming their primary care doctor. And so this idea of like charging for consultation versus, a membership, and maybe talk a little bit about, the legal considerations of like, hey, someone's like a member of your practice versus they just came in for like a consultation. And are there any kind of big things that stand out there, or is it still a similar consent in those two scenarios?
Yeah, so the consents for medical treatment are different than the patient agreement for a cash pay practice. And so it'll depend on the model you use. And we have 4 or 5 different patient agreements. And some people use several in their practice. Some people will have a fee-for-service agreement for an initial appointment. Then they might put people or encourage people to join like a 3-month kind of like a deep dive intensive thing. And then at the end of that, they might have them join like a long-term tail continuity membership type of thing. Just some things to look out for there is, if they prepay at once, then you have to put some of the funds in escrow in a lot of states, and they're entitled to a refund. You can't just be like, sorry, no refunds in medicine. They just have to pay for the services they're getting. For memberships and some of these programs in particular, you want to have very conspicuous language, what attorneys would say, mine is bright red and in bold. This is not health insurance, because we don't want to be confused with insurance, with the insurance codes of any particular state. Some states actually have, like, it must say that in the language. I think I'm thinking of Oregon has language like that in their code. Other states don't, but you want to make sure you're not being categorized as insurance. And so there's ways to do all of it. And there's even ways to accept insurance and have like a little monthly fee for some of the non-covered stuff, including oral messages, amenities, all that. I call that concierge. It doesn't mean you have to be 24/7 on call, but that's how I describe that model to people. So it's monthly fee plus fee for service with insurance when they come in. But yeah, all of that's possible. We handle it all at Functional Lawyer. My wife was really successful with the membership model after the initial appointment. So, yeah, all that can be done. And there's just, as always, there's just nuances to it. So just making sure that contracts sound scary. And a lot of people come to me, they're like, well, I don't want people to sign a million things. I'm like, well, you need at least 4 for the brand new patient. But it really, in particular, the patient agreement really helps both parties. It sets expectations, because having worked in litigation, and I'm an amateur psychologist, I would think that most disagreements that end up going to litigation, lawsuits, board complaints, bad reviews on Yelp or wherever, are a result of unmet expectations and, lack of communication. So contracts are good because they set the expectations. Here's what's included. Here's what's not included. Here's what we expect of you. Here's what you can expect of us. Here's how you terminate. Here's how we can terminate. All of that language is scary for a lot of people, but it actually is more safe. It helps everybody understand what to expect ultimately, and leads to fewer unmet expectations overall.
Yeah, maybe you could speak also to, you kind of brought up membership concierge, maybe speak a little bit to the difference between what is fraud in kind of practicing medicine and insurance versus not being it's not part of your contract. Not, it's, you know what I'm saying? Like, where am I trying to go with this? There's sometimes people will say you're oh, you're committing fraud if you bill for this procedure that you're doing, which it really isn't fraud, but how do you kind of counsel people to, what is fraud versus saying, hey, you're just not, meeting your agreement with your insurance contract? Does that make sense? Do you understand my question?
So Medicare in particular has a lot more restrictions than private insurance, which is based on state law. So what's definitely not allowed is having a patient pay and then not being happy with your reimbursement from Medicare or insurance, and then having a patient pay extra because you spent an extra 45 minutes with them or anything like that. That's called balance billing, and that's prohibited across the board. There's a lot of regulations around Medicare. You mentioned at the top of our conversation was with like opting out, non-participating, that kind of stuff. I'll leave that for a couple of minutes from now if we've got time. But as far as fraud is, don't bill for things you didn't do, and don't double charge for things that, you ought to only charge once for. Is kind of like the simplest way I could put it. So, balance billing is the biggest example, or just adding in codes that you didn't do just to kind of justify that you spent 30 minutes with them instead of 7, that is fraud, I would say. Like, you didn't actually do the thing, or it wasn't actually that complicated. You're just trying to get the codes in. So being honest with your codes, and then determining, and it's not the most scary thing in the world, because there are tons of practices that are successful with not being in insurance and not being in Medicare at all. You have to be a little more customer service focused. So you have to have a little better bedside manner, not only in the clinical room, but also with customer service. You have to kind of like be like Disney, or I'm reading the book by the Banana Ball founder who really models his stuff after Disney, just in creating great customer service experiences. So you don't have to go that far on the spectrum, but you do have to go a little bit farther than just showing up and seeing whoever insurance sent you that day. So, if you're not happy with what insurance is giving you, consider adding either a concierge membership model kind of thing where they're paying a smaller monthly fee for service amenities that are not covered by insurance, which is fine, and also fine under Medicare, as long as it's not covered. And then also, maybe down the road, consider if you want to go 100% cash too.
Great. We'll just slide right into the opting out of Medicare.
Oh man, how much time do we got?
We have 6 more minutes, so you gotta do it in a very concise Cliff Notes version here, Scott.
Yeah, I talk about this all the time. So the biggest misconception is that you can be in at the hospital job or the conventional job and out at your practice, and that you cannot do that. That's why I said Medicare is
all or in, right?
You're all in or all out. You're not like the California Burger chain in and out. You've got to be all one way or the other.
Or you're a little bit pregnant in one area, but not another, right? It's like you're pregnant or you're not, and it doesn't matter what location you're at, you're still pregnant.
Yes, exactly. So when it comes to Medicare, even if you say to people, I don't accept Medicare as payment, you're technically not allowed to see them for a covered service and then charge them cash. There are a few ways you could do it with some careful legal documents, but it still has some limitations on how much you can bill them if it's a covered service. So what a lot of people do is, if they have to have one foot in both worlds, they will say at their private practice, hey, we just can't see Medicare patients at this time. We only see people who are between 20 and 60 or something like that. That buys them about 5 years until they have to make a tough decision with their existing patients, assuming they stay 5 years. Or they talk to an attorney and they figure out how to do it safely, because it is pretty nuanced.
That was good. See, you made that in very good time.
We talk about it probably 2 out of the 4 times a week that we have office hours at Functional Lawyer. So I hear all the questions about it and know all the misconceptions. And it's always changing too. Like some of it, like I've never heard that before in over 8 years.
Well, one topic that comes up when I went through this last year was you can opt out with ordering privileges or without.
Yes, this is true.
Just comment on that briefly.
So a couple other things on opting out. If you are going to opt out, it is a 2-year commitment. You can't come back in until your 2-year anniversary. Quick exception, that the first 90 days of your opt-out period, you can change your mind, like if you made a mistake. only of the first opt-out period. But after that, it's every 2 years. It automatically renews. So you don't have to file again at the 2-year mark. But you can opt back in if you give them 30 to 60 days notice prior to that, I believe. Ordering and referring, or ordering and certifying, it's sometimes called. If you do end up opting out, you can tick the box on your affidavit that says, I wish to remain an ordering and certifying provider, which means you can bill for covered services for your time. And then when you do order prescriptions, tests, those sorts of things, Medicare can cover those through those third parties. So it saves your patients a little bit of money. It doesn't cost you anything to tick the box that says, I want to remain ordering and certifying, or ordering and referring.
And then I think just one other comment would be, in case there are other listeners who have no clue how to do this, like I did when, and like, obviously working with you, you would probably guide them, help them know what to do to fill out the affidavit or whatever. But if someone wanted to do it on their own, is there some quick advice you can give as to where they can go to learn how to do that, or to
Yeah, most of the MACs, or Medicare Administrative Contractors, have good step-by-step directions on their websites. For California, I believe it's Noridian, and Noridian has a couple of regions. Novitas is another one. CGS Contractors is another one. There's about 6 or 7 of them, and they each have a different region of the U.S. with 3 to 5 states in it. So just Google who are the MACs, and you'll get a PDF from CMS, and they'll know who is your MAC. And then you go to that website, go to Medicare Part B, and then go to provider enrollment, counterintuitively. And then they'll have instructions on how to opt out there.
Perfect. Thank you. I didn't know what a MAC was before I did that. So it's good.
They're the people that do all the Medicare processing, because they're private contractors instead of having government employees do it. So they bid and win contracts to handle this, just like a mortgage servicer would bid to get your mortgage, something like that.
Well, Scott, this has been fantastic. And if people wanted to, ask you a few more questions and pay you to do that, which I think is appropriate, how can they find you? Where can people find you?
Yep, functionallawyer.com is the best place to get in touch with me. We do have free discovery calls if you want to learn more about what it looks like to work with us at Functional Lawyer. We do also have a business mentorship, my wife and I. Linda probably talked about it on her episode, which was, it's called Origins Incubator, and that includes a lot of me and legal in that as well, but includes business, marketing, clinical support as well. But Functional Lawyer is the best place to get in touch with me. Follow along for more legal, free blogs. I have a podcast that, I put out occasionally. And so definitely follow for the free stuff. And then if you're interested in working, we do have the free discovery calls there too.
Awesome.
Amazing.
Thank you very much. This was great. And I would ask you another question, but I want to make sure you get to your next appointment on time. So we'll call it good right here. And, again, appreciate you having the time to spend with us today. And I'm sure it was valuable for us. I'm sure that anybody listening to this is going to find this extremely valuable. So thanks, Scott. Really appreciate it.
It's been a pleasure to be here.